Good morning, everybody. Welcome. Just such a lot happening in the public procurement space, and so pleased to have Professor Geo Quinot with us this morning to discuss everything that's happening, and there's a lot that's going on, Prof. Professor, you're a professor of public procurement in Stellenbosch University, and certainly one of the foremost academic speakers, specialists, consultants, advisors in public procurement, not just in Southern Africa, but also recognized globally, and really pleased that you can join us. Prof, let's kick off with, I think, just recognition that the Public Procurement Bill was approved by Parliament last Thursday and is sitting with the President for assent. I understand that there are 36 or 39 bills that are sitting on the President's desk at the moment, so he's got quite a lot to do. But before we get there, perhaps let's talk about what's going on today and what many practitioners are dealing with at the moment, which is preferential procurement and dealing with the implementation of the preferential procurement regulations 2022. Now, there have been some developments in court on that, and I was interested to see an email this morning from someone who is in the Western Cape, and I thought he was very aware of what's going on in court on this, but was surprised to hear that there are indeed some court challenges in that respect. And I know you've been doing some work on that and would like to give us an update.
Yeah, sure. Thank you. Thank you for inviting me, Sean. Always great to engage on this platform. So I'm just going to quickly share my screen. I just want to share some of these details with the colleagues so that they've got the references and all of that. They want to look at this in more detail. Right. So you can just give me a shout if you can see my screen.
We can see that, yes.
Okay. Brilliant. Okay. So I thought I'll just quickly share this with you because there does seem to now be a bit of a trend going on around the country. There's now, to the best of my knowledge, and there might be more, one doesn't always know these things coming up through the high courts because usually they run in the first leg just on interim relief. So that's the typical approach. The supplier is unhappy with the award, rushes off to court to get an interdict to interdict the organ of state from proceeding while the review is now being done. And all of these cases have been on that basis up till now, and there might even be more because we don't always see those reported or coming up through the system. But there are at least these three that I'm now aware of. Now, the Sunroll one seems to have gone away. Sunroll seemed to have, settled, or whatever you want to call it, decided to kind of reconsider. But there's now been, in the first few months of this year, been two others that I thought is quite interesting, and I thought I'll just quickly share with you what's going on there. So the first one is this, sorry, I see my slides are somewhat in the wrong order. Okay, never mind. Let's go to this one first. Okay, so this is the Western Cape one. It's against the city of Cape Town. Oh, sorry, no, my slides is not incorrect. Sorry, I forgot that I wanted to say something about this first. Yes, there we go. So this is just for everyone's benefit, those that do not, as I do, spend all your waking hours looking at all the procurement laws. Just a quick reminder of what the background to all of this is. It's, of course, the aftermath of the Agribusiness case in the Crown Court and the subsequent replacement of the 2017 preferential procurement regulations with the 2022 preferential procurement regulations. Remember, that whole development didn't touch the Preferential Procurement Policy Framework Act. The Act itself remains untouched. It was never about the Act itself. It was only about the regulations under the Act. So that's a big point to remember, because the other topic that we're talking about, and that's the procurement bill, will of course now replace all of it. So what we're talking about at the moment is simply the implementation regulations under the Act, and the Act remains untouched. So the new regs, the 2022 regs, replacing the 2017 regs, basically left the entire determination of the preferential part of your adjudication. And that's still the familiar 10 or 20 points, depending on where you are in terms of that threshold. It's now left the calculation of that completely to organs of state themselves. So it's a complete hands-off. It gives no prescripts whatsoever. All you've got is what you see on the screen. Regulation 3 saying that you must determine your own point system and you must state whatever it's going to be in your bid documents, and you must refer to these specific goals. This is simply also just the definition from the Act itself. Really important to note that when they define specific goals, so in other words, the things that may go into this 10 or 20 points, it uses the word include. So it says it may include the following. Now that's of course open-ended, right? That means these are the kind of things that you could do, but it's not restricted to them. It's not prescriptive on how you calculate any of this, what you include, why you include it, how you're going to measure it, nothing. That's up to you in both your SEM policy and then in the particular bid document. Now, that's the background. And of course, we all know that all organs of state since 16 Jan last year have been kind of rushing to get this in place. And we've now seen really weird and wonderful experiments across the country that I think is quite interesting. And it's on the back of that we see these cases. Now, the first one to briefly just note is this one from the Western Cape. It's against the Cape Town municipality, City of Cape Town. What's interesting about the City of Cape Town's approach to all of this is that in their revised SEM policy, if you go and look at that, they've kept it very open-ended. They've basically cut and pasted 2022 regs into their policy and really left it open-ended for the individual tender. So in the city's approach, every tender now, they decide how are we going to do this 10 or 20 points. And so there's no overarching prescript in the SEM policy itself, which is the case in many other entities, not in the City of Cape Town. So this is determined on a case-by-case basis. And this is the one that the case is about. At least in one is 2 tenders, but this is the one. So if you look at this, it's quite a departure from what we had before. Those of you that's been around the block will remember under the 2017 and 2011 regulations, we simply just use a very straightforward matrix, little table. You checked the bidder's BEE certificate, whatever level it is, it gave you a number out of 10 or 20, that was that, right? So very, very simple system, fully piggybacking, if I may use that term, on the broad-based Black economic empowerment scheme. If you look at this, this is now for this particular tender, you can see it's a completely different story. So this was a 90-10. And if you look at how those 10 points are then calculated, it's gender ownership with a score there, race or Black person ownership with a score, disability with a score, and then micro and small enterprises with a score. And that's that. So that's how they calculated the 10 points in this case. I think what is important to note in this particular example is that there's no reference to B at all. Right. So this thing is calculated completely outside of the Broad-Based Black Economic Empowerment Act scheme. Of course, there's great overlap, right? So most of these criteria that you see here also forms part of that scheme. But this one is a freestanding. It stands on its own legs. It's got its own measurement. Right. So this was the calculation of the 10 points for this particular tender. And one of the bidders, H&I, that's a big player in this space, been a big player for a number of years, get a big chunk of their work in this whole infrastructure space, approached the court to review the the tender document, and specifically this element, this little table you see in front of you. And the argument is that this is unlawful. Now, important to note, really important to note, that this case, the one you've got the reference in the table on the screen at the moment, is just what's typically referred to as the Part A of the case. It's just to get interim relief. It's purely just to interdict the city from proceeding with this tender pending the review, which will be the Part B. And the court granted this, right? So this tender, these two tenders actually, is now been interdicted by the High Court. The city is not allowed to proceed with it, pending the review that must now still happen, and that will take some time, right? It'll be a bit of time before this is in court. Now, I think what's interesting about this case is this argument, and this is now where it seems to be a new trend. The BEE Act has got a very specific trumping clause, clause 3, which you see there. 3.2 is the one that we're interested in. And 3.2 of the Broad-Based Black Economic Empowerment Act says that this act trumps any other earlier enactment. Now, it's important to remember that the triple PFA regime precedes the Broad-Based Black Economic Empowerment one. It's a 2000. The triple PFA is a 2000 statute. This is the argument that's been presented. Now, again, this is interim relief stage. The court doesn't have to finally decide on this argument. It's at this stage of the fight, the court only decides whether there's a prima facie case, whether the applicant suggests an arguable case. And it's interesting to note the court's comments in this regard. I've got it on the screen there for you. So the court says the applicants and the city are at loggerheads about whether or not the Procurement Act, that's the triple PFA, or the Empowerment Act, that's the Broad-Based Black Economic Empowerment Act, should take preference in the new scoring system. You can immediately see that that is a key question at the moment. When you are now required to design your own preference system under the 2022 regs, that's a key question for you. The court says, in my view, there is presently enough pointing to the determination of the legal question in the applicant's favor. And that argument that they're making is that it would be unlawful for an organ of state to use anything but the BEE certification mechanism to calculate preference. So what the applicants in this case, H&I, is arguing is that the 2017 and the 2011 approaches was the only lawful one that could be done given the BEE Act's trumping clause. And you see the court, at least at interim stage, remember, Ben, very important to point this out. This is not a ruling by the court. The court's only looking at whether there's a case to be made. But you see the court is certainly inclined to that view. In Part B, that's the review. Whether or not the city is complied with Section 217 in introducing its new scoring system will be determined in Part B. That's the review, and it is in this respect that some doubt may lie. So the court says, well, who knows? This must be argued now. We must look at this matter. But I think it's a really interesting development, and I think there are real implications if this should follow. The second case, very quickly, is this STEAM Development Technologies. Eastern Cape case, Makanda, but it's against National Public Works. So a completely different level, same story. Again, this is just an application for interim relief, stopping the tender from proceeding, pending the review. And here I've got the scoring system at issue in this tender. Again, this is a 80-20 tender. This is how the 20 points will be calculated under this particular tender. It's also in the broader workspace, although this is a services contract. It's boiler maintenance at prisons, I think. And this is the scoring chart used in this particular case. So there's an EME QSE ownership by Black people. There's a localization element there. Black women ownership element. Black people with disability ownership element, and then a Black youth element. And indications of how that is to be determined. Interesting that some of the BEE mechanisms are still being used as proof,
Mm.
but that is to validate the claim. That is not in itself the requirement. And again, we see the very same argument being made in this matter. And again, I think very interesting to see early indications of a court's view on this. Again, in this interim relief stage where the court is very tentative, doesn't have to take a final decision, just figuring out whether there's an arguable case. We see the court saying the right that the applicant, the one that's asking for the interim relief or the interdict is trying to protect here, that right is threatened by the introduction of a scoring system that seemingly failed to consider a relevant code of good practice issued in terms of the B-BBEE Act. This is quite a strong statement in interim relief.
Mm.
The applicant's detailed submissions on the mandatory application of the construction sector code as amended, its significance in the context of the Construction Sector Transformation Charter and the B-BBEE Act, and the contrast with the new scoring policy have simply been ignored by the department in its papers and during argument. The applicant has, for this reason alone, satisfied the requirement of a prima facie right to protect the relief it seeks in Part B proceedings. That's the actual review, based on non-compliance with the applicable legal framework for preferential procurement policy making. So I think this is very interesting. A lot of development. I think this is watch this space kind of thing. If any of these two cases on the actual review were to succeed, I think, just based on very cursory look at what entities have been doing since January last year, the vast majority of organs of state in this country will again be back at the drawing board.
Yeah.
With their preferential system. And who knows what is the correct answer? I think it's an arguable case, but the courts in the end will have to tell us.
Yeah, Prof, it's interesting. I see your hand there, Ingrid, but just before asking you to come in, Prof, if you wouldn't mind still sharing that last case in the Eastern Cape, the wording that they've used there in the second line is from 10(1)B of the B-BBEE Act, where it says the organ of state must apply any relevant code of good practice in implementing its preferential procurement policy. That's 10(1)B. I'm not aware of 3 in there. If you could just stay there. To the City of Cape Town case. The reference in the City of Cape Town case to Section 3 of the B-BBEE Act. Sorry, if you can go forward.
Yeah, that one.
Section 3.2. I'm not aware of that one, and I would certainly need to look at it. So it's certainly 2 different parts of the Act that these 2 cases are looking at.
And Sean, it's a very important thing to point out, because only one of them would have also far-reaching future implications under the new Procurement Act. So this one that we're looking at now would potentially go away if the Procurement Act now kicks in, because the Procurement Act, of course, is now later than the BEE Act. So this provision would no longer trump the Procurement Act, even though it trumped the PPPA, which is interesting.
Yeah.
Because we might have a very weird scenario where we have a court say, let's say under this Cape Town case, that no, you couldn't do this. You had to align with the BEE Act because of this provision. But then within a short period of time, we get the new Procurement Act and the position changes again. And that's where the provision you refer to, the Section 10 one, then becomes critically important, because that one is not conditional, as this one is, on whether there's pre-existing or post-law. There's no timing issue there. It's a straight out, you've got an obligation under this Act. And I think that is going to be undoubtedly a difficult thing to square under the new Act.
So a couple of things. Ingrid, I do see your hand. We'll bring you in shortly. Which is the pity that the Sunrail case didn't go on, because that would have given us some direction. And right now, organs of state, all 700 plus of them, are unsure. There is a guideline issued by National Treasury that says if you do put the B-BBEE scorecard in your preferential payment policy, it could be an irregular expenditure finding. And so there is a perspective from Treasury. There are now 2 court cases, 2 in court. A question, and then we'll come to Ingrid. The question is, the City of Cape Town, I think, is they're both 30 January. Interesting.
Yeah. Yeah.
No, 30 January. I think Eastern Cape is later.
Yeah, but it was only Eastern Cape is later, but it was only the reasoning provided.
Okay.
Interdict was actually, I think the Eastern Cape one might have just been days before the Cape Town one. If you look at the reasoning in Eastern Cape, they even refer to the Cape Town one in the reason, but the reasons were provided. So the interim relief was provided, I think also at the end of Jan, and then reasons followed a few days later.
When do you think these cases might end up in court? That's the question.
Well, I think it's a difficult one. It's a difficult interpretation. But I'm leaning towards the view expressed tentatively in both these cases, that if I put those 2 statutory provisions next to each other, I'm also leaning towards the view that they may be correct and that there may be a limitation on what you can do. Of course, this is the first time that we've had this argument, right? We've never had this before, but it is because since or not since, but for a very long time, under these 2 acts existing together, we had practical alignment. So we didn't have to think about this thing, but now we do. So my sense is that there might be merit here. I mean, clearly, both judges think so. And these are, I can tell you, all judges, of course, are good. These are 2 particularly good judges.
Interesting. Ingrid?
Yes, hi. Hi, Prof, and hi, Sean. I think just to go back to what our submissions were from the Construction Charter Council in all these hearings was the fact that in 2014, the BE Act was revised, where they said previously, if an organ of state is doing business, where reasonably possible, they must apply the BE codes, and that was changed to must. So that was a very, very strong message that it has to be taken into account. Okay, and what we objected to was the drafting of the procurement bill clearly trumped the Act 53. In two areas, they trumped it completely, which leaves industry with a very big question mark. I mean, just a simple case now, if you look at the City of Cape Town, their definition of an EME and a QEC is completely different to Act 53. So, there are no rules left, basically. And what we said with removing sector-specific codes was a big protection in our industry against fronting. Because what can happen now is that based on these preference points, an entity will get a huge price advantage, and there is nothing to stop them immediately subcontracting that work to someone who doesn't apply. The construction codes give guardrails to subcontracting. You cannot subcontract more than 25%. So that was our issue in actually saying to Treasury, you are clearly trumping it. You are going against what was said in 2014. And this is the result now, is that every state-owned enterprise is devising their own criteria which do not align. So you can't even certify your ownership by taking along a Senate scorecard if their definition of an EME and a QEC is completely different to the codes. So, yeah, that was my point, and that's why they willfully put into the revision D that it trumps Act 53. If that's the case, that's fine. Let's just scrap Act 53. But industry needs to have some certainty so they can align businesses, and that was our issue. Thank you.
Thanks, Ingrid. You join us regularly. Just for those who don't know, when you say we, who is we?
The Construction Sector Charter Council. I'm basically the assistant CEO, and we run the codes of good practice and we've also written to the City of Cape Town to say that we are concerned by the proposed procurement regulations. They haven't interacted with us. Their policy, and SANRAL didn't interact with us at all. So that was my little
Ingrid.
2 cents worth. Thank you.
Thank you.
Sean, I mean, I think Ingrid makes a number of really important points for us to really think about in this space. And I think the one I really want to pick up is the risk that organs of state are creating for themselves with this kind of practice. Because remember, if you put this type, and let's go to one of those examples, right? If you put this type of requirement into your procurement, then the obligation is on you as an organ of state to ensure, firstly, that it is correctly measured. So whatever, proof you're looking at, you need to be sure that that is properly done. And secondly, when you award, then on the basis of that, there's an obligation on you to make sure that it remains like that. So the point that Ingrid made about fronting is a particularly important one. Because remember that we've had clear authority, for example, from the Constitutional Court in the Vaiki Pony case, which also involved Cape Town, to remind everyone, where the court set out quite clearly the obligations on an organ of state the moment that there's an allegation. And those aren't easy, light things to do. You must do a proper investigation. Now, when you do something like this, or let me put it this way, the further you move away from, let's say, just a BE certificate, the greater the risk, because the bigger the obligation on you to do additional due diligence, to be able to investigate when there's a complaint, etc., etc. And the other thing that colleagues must bear in mind is that very recently there was an amendment to the Prevention of Corruption Act that's now made it an obligation, a duty, to investigate and take action when there's allegations of corruption, on the pain of committing offense yourself. So this is serious stuff. When you put out a tender, this is the dimension you put in, and now there's an allegation, as is, I mean, we know this space. There's often these kind of allegations. And then as an organ of state, the risk is very high. So I think this is something that organs of state must really very carefully pay attention to. The other thing that I think is quite interesting from what Ingrid said, and I think in this regard, the Cape Town case is very interesting, especially when you go and look at the judgment, is one of the big arguments that H&I is making is that for years, they've adopted, sorry, not this one, they've adopted a very particular approach to empowerment, which involved an employee share scheme. Again, a very familiar model. They've quantified the extensive amount of value that's been transferred. And what they're arguing is that if this new scoring mechanism goes through, it will destroy that mechanism completely. I mean, you read the interim relief judgment, you can see that the judge was clearly very sympathetic to that argument. And I think that really brings home the point that Ingrid made around industry needing certainty.
Yeah.
And then I think the last point is just to remind everyone of the lawmaking process around the bill, and that at some point in the many different iterations of Chapter 4 that we've seen, we had Section 10 hardwired into Chapter 4, and that seems to have now fallen by the wayside. I think which is going to make this argument even harder.
While you're on that slide, it says in the event of any conflict between this act and another act. And what some of the policy work is that we've done, Prof, is we've tried to harmonize the two in the policy and include in the policy both the BBBEE scorecard and specific goals so that we can tick both boxes. But it was interesting, as Ingrid pointed out, on HNI and the City of Cape Town, they don't even use the same definition of small business, whereas they have in the Eastern Cape case.
Yeah, and I think, I mean, the point that Ingrid makes is a really fundamental one, and that is the moment you do that, the moment you change your definitions, your categories, you cannot rely on these third-party instruments anymore. You make it impossible for yourself. Now, why would you do that? I mean, why would you make it so difficult for yourself? Whereas if you keep to the same definitions and the same concepts and the same categories, at least you can use those mechanisms as proof, as evidence of whatever it is that you want to put into your preference score, which of course makes life much easier for yourself.
Thanks, Prof. Let's jump to Chris Wilcock and then we'll go to Nicholas Diaz. Hi, Chris. Good morning.
Hi, morning, everybody. Thanks for the opportunity. This very morning, a City of Cape Town tender landed on my desk, and it contains the exact same table as in the H&I case, albeit on 80/20. So they're forging ahead with exactly the same system and policy. Now, with one interdict against them already, would the next interdict not merely be a formality? I think I'm not sure why they're carrying on like this.
Thanks, Chris. Let's go to Nicholas and then we'll ask Prof to respond. Hi, Nicholas. Good morning. Welcome.
Hi, good morning. Just very quickly, do we know or have we heard if the city is planning to launch a counter application regarding 10.2? Basically something along the lines of arguing that it's not consistent with 217. Anything anybody's heard or thought? Just because it occurs to me that if there's going to be a fight in the procurement bill, and if they win on that space, their hands will still be tied under the under this act if that's not resolved.
Yeah. Thanks,
Nicholas. Prof.
Yeah, that's a really good point. I mean, I've got no chatter around any of this. It's a good point. If you look at, just quickly want to go, if you look at steam development, no, sorry, it was actually H&I. Sorry, I just want to get to that bit. You see clearly there in those remarks the court bringing 217 into the mix as well, and I think foreshadowing this question of the alignment between different statutory regimes that is, you know, in this space, but also going forward under the procurement bill, dependent on cross-trumping clauses, which is messy at the best of times, can be resolved if we have a definitive view under 217. So that would be strategically the best thing to do, and the city, you know, wink, wink, can really do all of us, the whole community, a big service by now actually putting this thing squarely on the table. So one would hope that the city does that, or somebody does it, so that we can get clarity. I mean, or Public Works can do it in their case, because Nicholas is absolutely correct. You know, this is all good and well. It's a very temporary fight for as long as the PPPFA is still with us, and that could be short-lived, right? By the end of the year, we might have a completely new system, and then all of this is just by the by. Chris's point, Chris, my mind also boggles. One would think that if you've got an interdict against you, freezing one tender because of that very provision, you wouldn't go ahead. I cannot explain it, because if I were to be a supplier falling foul of those requirements in any of these other tenders, that would be the first thing that I would do. And it would be very, very strange if you approach the same division of the High Court on interim relief basis and the court would find differently. Of course, it is possible, because remember, for interim relief, one of the requirements is a balance of convenience. So in where does the balance of convenience fall in stopping the procurement or proceeding? Now, I've often said that as an organ of state, I think you've always got the upper hand in that fight, provided that you frame it properly, because you just need to convince the court that the stopping of this procurement is going to have some really big impact on public services, which I think is mostly fairly easy argument to make. And you can swing the balance of convenience in your favor that way. Didn't happen in this case. Not to say it can't happen in a different case, but of course that would be an untenable position, that you've got one tender frozen because of this, another one proceeding. And at the very least, the city then runs the risk of the review application in one case succeeding, which would automatically mean that all these other tenders that's since been adjudicated and awarded would all then become irregular. So there's a big risk there.
Yeah. And we're not going to ask the City of Cape Town people who are online today to respond. This is in court, so we'll leave it there. But the fact that they still continue to put out tenders with the same construct means they probably think they have a case. Let's jump to Tundi and then Freddie.
Morning, colleagues. I was hoping, Sean, that you'll twist their finger to say something. Offline, we have a virtual confidentiality clause in this meeting. Whatever it says here stays here. Sean, I'm hoping that Prof Quinot can really help me with this one, because there's something that really confuses me about these court cases. That there's PFMA that legitimizes National Treasury and its role, right? And now we have these problems now whereby these contractors are picking up gaps in the legislation. Why are they not taking on National Treasury instead of taking the organs of state? Because now, even with Cape Town, as much as they have been interdicted, service providers don't know that there's another service provider that's interdicted this process. So they will just see a tender and they'll continue and respond. So my question is, because National Treasury's silence, I remember even with the Central matter, it was quite worrisome for me, but at the same time, I understand the Central matter where they were coming from, because they were against that to begin with. But now there's this one that's now questioning their own position or guideline or process. And now the question is, maybe shouldn't it be like a joint kind of response thing, like, this interested friends of City of Cape Town, and then maybe they respond to actually support them, because I think the people who are best positioned to defend this, it is actually National Treasury, because a lot of organs of state, as much as they would wanted to do things their way, National Treasury has PFMA that empowers them to actually give instructions to organs of state. Therefore, what can we do? We have to comply. My expectation is that they would at least be participating in this litigations. But really, my question is, why aren't these providers taking National Treasury on as opposed to?
Thank you. Let's jump to Freddie. Thank you, Tundi.
Good morning, Prof, Sean, and colleagues.
Good morning.
I think my worry is if we can check most of entities or departments, we have crafted, or we are crafting our tenders in the way that the City of Cape Town and the public will sometimes have crafted.
Sure.
And then my issue is, what must we do as policy drafters or practitioners in the supply chain? Because it looks like everything that we are doing is being challenged.
Yeah.
And now we don't know which one is correct, which one is wrong. Thank you.
Yeah. Thanks, Prof.
Yeah,
that's the big question. Hey?
Yeah, two really excellent contributions. Tundi, I think it will be difficult to join National Treasury in any one of these cases, because they don't really have a direct interest in the order. right? So remember, the test for joining is whether another party's got a direct interest in the order. Now, the order being sought here is an invalidation of, in the one case, the city, in another case, Department of Public Works' scoring of preference in a particular matter. And Treasury doesn't have a direct interest in that. That's not to say that Treasury doesn't have a role to play in the broader scheme of things. And this is where I think you're right, that one would hope and think and suggest that perhaps it might be in the country's interest for Treasury to apply to be admitted, at least then as an amicus, if not just supporting their fellow organ of state in this matter, to help the court to bring clarity to this matter so that we get an answer. Because I think that the question Freddie is asking is the key question. That's the big one. I mean, okay, fine. There's 2 tenders or 3 or 4 tenders now between these 2 cases. Who knows where they'll go? But of course, we know, as Freddie points out, that this has got a much bigger impact. This is of the level that we saw in 2022 May, when Agribusiness just hit. And nobody knew, well, very few people knew what the heck is going on now. Treasury put out those kind of communications to say, look, just wait, just don't do anything because we just need to get clarity on this. We're in that space again, or perhaps I should say still, because I don't think we've ever had certainty since that case. And just as an aside, Sean, I think what we're seeing here is a really important case study, reminder, signal, whatever you want to call it, about why a lot of us been putting a lot of effort into the new procurement bill before Parliament, to say to Parliament, it's not that we are wanting to oppose this thing or anything. We want to avoid exactly this, what we are seeing now, because as a country, we can't afford this. Nobody can afford this uncertainty, the impact it's got on business, the impact it's got on service delivery. This is a nightmare. We need more certainty. And I think this is exactly what's playing out here. Unfortunately, the space we're in at the moment, I don't see an answer coming down the line in the short term. I mean, these review cases are not going to be heard quickly. They're not going to be solved quickly. And then we're only at high court level. And, you know, I think that there are legitimate, reasonable views on both sides. So, I mean, I don't think one can simply just dismiss, for example, any of these organs of state in the way that they've done it, or Treasury's kind of communication on what they think is appropriate out of hand. I think there's merit there. One must carefully weigh it up. My own view that I've often stated is the safest route, in my view, is to do exactly what the 2017 regs did. And your authority for that is paragraph 116 of the Agribusiness judgment. So if you go and look at that judgment, that's in the majority judgment of Justice Mtlanga.
Yeah, right at the end.
He says there, what the minister tried to do in these regulations is exactly what 2172 of the Constitution contemplates. The only problem is the minister couldn't do it. Now, to me, that is as clear an indication we've got at the moment about what would be constitutionally compliant. So for me, that's the safest route to take. But of course, you know, we know that there's this communication from Treasury. Perhaps I should just, Sean, quickly, MP, one of my absolute star former students put this in the chat. Could the rationality of the preferential procurement policy be challenged where the variability of the preference measures are uncertain? Since the BEE system at least provided a trusted verification system, how can unverifiable preference stipulations be rationally linked to the fulfillment of specific goals? And I think there's I think, MP, you've, as always, got your finger on the right argument here, that I think there's going to be, I think that is going to be a key question. If one can push that decision, and I think this is where Cape Town has probably got a harder case than Public Works, because if I'm not mistaken, please correct me if I'm wrong, because I couldn't get onto Public Works' website. It's down for some reason. But I don't think that table in the Steam case comes directly from, I don't know, I think it comes directly from the SEM policy of Public Works. I'm not sure. But I know for a fact, checked it, the City of Cape Town's one, of the City of Cape Town case, that table does not come from the SEM policy. So that suggests that the actual table is not a policy decision.
Oof.
It's an administrative decision
Oh.
taken by the BEC in the instance of the particular tender. That means the decision to adopt that particular scheme is subject to administrative law, not just general legality. And in administrative law, you can review for proportionality in addition to rationality. And MP, I think this is where your argument is probably going to get legs. Because when you go beyond rationality and you have to show necessity and suitability as part of the reasonableness test, I think using an untested kind of unverifiable thing is going to be difficult to justify. So yes, I think there's a lot there.
Yeah. Thanks. A couple of points in the chat. Just for the record, National Treasury is online today, but I certainly don't want to put them on the spot and bring them in on this discussion. They're listening, and I'm sure that many of the points that are coming across today will be taken back to the different teams. There are different teams in National Treasury. It's not so it's not just one cohesive group of people. If you could just go back, Prof, and then I think we must move on to the next topic because it's related. Just go back in your slide to the actual template that they used in Cape Town. Yeah, there's and I'm not sure if they shared in the right-hand column there the proof that they were looking for. They might have had something there.
Yeah, let me quickly see if I can just pull that onto the slide as well. I've just moved it to make it more visible.
Sure.
I think it is there. Let me just quickly see. I think this thing is just cropped.
Okay, it's cropped, yeah.
Let me just see. Hang on. I will
Okay.
see if I can get it back for us. No. No, but
because those are very, very different measures that are stated there, and so the because the Preferential Procurement Policy Framework Act is very clear that the measures need to be objective, measurable, and monitored.
Yeah.
Which is the positive of the B-BBEE Act scorecard. We have all right. So you're saying that the chance of these courts giving us a precedent is a long way away.
Yeah. No, I think we're still some time off. So I wouldn't expect a quick answer.
Okay. If we can jump then to the public procurement bill, currently still a bill. Should the bill then move into an act, Prof? Practically, what does that mean then to organs of state? I see you might have found it there. Okay.
Yeah, sorry. Let me just quickly.
Let's have a look. Yeah, absolutely.
This was from the presentation in one of those Cape Town tenders, and there you see a little bit more. I couldn't create the actual. It's one of the things about our procurement information system that the moment a tender closes, all the documents disappear from the web. But this one I could track down at least the presentation, and there you see some documents, but not all. So, for example, on the first one there, it's company registration certificate. So a mixture of mechanisms. Anyway, okay.
Which is common.
Yeah.
which is the administrative overhead that we've got now as a result of this as well. As there was
Yeah,
one
yeah.
certificate which was used previously. There are multiple, and each of these need to be checked.
Yeah, and something like, for example, localization, which is very common now as well. You
Sure.
get asked to give a rates bill.
Yeah.
Now, I mean,
or something.
my question would be, you know, when you look at that rates bill, there's a lot of due diligence for you to make sure this is the right entity. You know, it might not be the one that put in the tender. They might be in a building with a holding company or completely different entity. Is it even accurate? There's a lot of questions there, and it's difficult. Anyway.
Yeah, physical location, is it in the area? All right.